Well, for those that are listening on the lecture stream, my apologies. I'm just going to do a quick recap inside 30 seconds because, kind of embarrassingly, the mic wasn't turned on. So we're talking about standing, and a couple of things to note about standing is that at common law, the type of remedy that you are seeking changes the rules that you need, or the hurdles you need to jump through in order to prove that you're sufficiently connected to a matter in order to trot off to court, in order to seek a remedy. Okay, and so here we're talking about equitable remedies, because as well as these prerogative common law writs, there's the great three: certiorari, prohibition, and mandamus, changing a decision, stopping a decision, and making a decision maker do a decision, the three big writs. You also have the writ of habeas corpus, which is an ancient common law prerogative power forcing the decision maker to bring the person before the court, and quo warranto, which forces the decision maker to show the authority that they make a decision under. So here, though, we're looking at the equitable writs or equitable remedies that you can seek. The injunction is making somebody do something, or sometimes, but usually stopping them from doing something. And if they don't do the thing, no government agency is actually going out. It's just a piece of paper. But if they don't do it, they're in contempt of court. So if an injunction is granted and the party who loses, who has the injunction granted against them, again here with decision makers in the executive arm of government, but sometimes, again, they can be private bodies and private citizens, again, that Proserpine Golf Club case. If they don't do it, they can be locked up. You literally can be locked up by the court for just ignoring orders, these equitable orders, these injunctions. The top one, though, is interesting. A declaration is essentially a preordained set of decisions that are sort of done essentially ahead of time. If we stop and think about the way courts work at common law, you have an issue with somebody, something happens, something bad happens. There's somebody spills paint all over the floor and you slip up over it. And so you have to then trot off to court and determine whether or not, in that case, in negligence, whether or not they owed you a duty of care, whether or not the appropriate standard of care they've fallen below, and whether or not falling below has caused you harm. But if we think about that, that's the courts, years after the fact, determining the rights of the parties at the time. It's retrospective. That's how the common law works. And it's a little quirky because we think of Parliament creating laws retrospectively as being the hallmark of tyranny. People going through and passing a law that says it is a criminal offence since the 1st of January 2019 to wear a Nike shirt to an undergraduate lecturer. That is, again, that would create outrage amongst the community, and in terms of Parliament, get kicked out. But courts do it all the time. It is their job to determine the rights of the parties back when the matter actually happened, when the breach happened, when the decision was made. Okay, now, what a declaration is an order from a court saying, if this matter would come to court, this is what we are going to say. So essentially, it's making a decision in advance. But courts can never bind themselves. The principle of stare decisis means that a decision of a court at the same level can never bind itself. So as a result, this remedy, a declaration by the court, is in its equitable jurisdiction. So these two remedies are in equity, and as such, all of the other rules of equity are going to apply. The clean hands doctrine, the equity does not assist a volunteer, essentially that idea that you are going to a court of conscience almost sounds like a contradiction, and in order to seek a discretionary remedy. These things are never granted by right. The court will determine stuff, and they will look at all of the circumstances and determine whether or not it is against bad conscience for this thing to, and as such, to grant this particular remedy. But an important thing to note about declarations, by convention, government departments always follow them. That is a convention. So if a court makes a declaration in relation to an administrative decision maker in government, by convention they will follow them. It's not a rule. They can still go through and do whatever they like. Often they won't, and often if the thing is sufficiently problematic, they go back to Parliament. Go back to Parliament and say, we need to change this particular law. All right. Right. Prohibition. This is a common law, and this involves a relatively wide test. All right. And as such, in some circumstances, the standing rules are very, very, very low, very wide. And that can happen in this first set of circumstances where there's something which is absolutely obvious to all. So that when you're applying for something, and again, this is really grounds more than strictly speaking to do with the remedies component. If this, for example, if there's a particular decision maker has made a decision and they're not doing it under an enactment. So we make a decision that we think is part of our prerogative power of the executive, or, and again, thinking about private bodies like incorporated societies that are making a decision, and of course it's not a decision made under an enactment, so we have to use the common law rules. But if it is so obvious that it actually goes against a particular statutory rule, it's going to be outside the scope of their powers, and the bar for seeking a writ to stop them doing that is really, really low. I think it says something like essentially nothing. It says there has no requirement, but strictly speaking, it's just a very low bar. Hey, this decision maker has made a decision, and it's not a decision made under enactment. We're seeking a common law writ. As such, if it's patently obvious on the surface of a statute, usually one that they're in ignorance of, the ability to go and seek a writ, stopping them do that, demonstrating, hey, look, they are outside the scope of their powers, they need to stop doing that, is a very, very low bar. Now, that's for very obvious things. For things that are less obvious, for where there may actually be some more serious statutory interpretation, or some interpretation of common law rules, where things aren't so obvious for a person sort of outside. In that situation, the courts will actually go and work out whether the person seeking this particular writ to try and stop an administrative decision maker from doing something is actually sufficiently connected. And so that we use that word aggrieved. Remember that the term aggrieved is the statutory definition, that you must be a person aggrieved under the statute. That actually flowed from common law test as well. So here they're saying, look, for prohibition, if there is like a massive defect, a defect essentially on the face of it. You know, you've read this particular statute, and the decision maker has gone and done, sold off government department stuff, and they're not doing it under an enactment. Cabinet has made that's not an example. I'm thinking of the Proserpine Golf Club. They've just gone and they've sold all of their shares that they had that were owned that were bequeathed to them in some legacy, that they have full legal title over. They've gone and sold it, and it's just, on the face of it, it goes against the Act, so the Associations and Corporation Act. So we've got a decision which has been made. It's not under enactment, so we're using a common law writ here. And if it's just patently obvious, the statute says you can't do this, we need to stop you doing that, that's very, very low bar. If, however, it's something more complex and it requires more difficult interpretation of either that particular statutory rule or set of rules. For example, the committee must take due care while selling these things. You have to analyse the factual matrix here. Do they take due care in terms of doing it? That's going to be a little bit trickier. Or if we had to look, and again, I'm thinking that incorporated societies doing this, if they were going off and selling a packet of shares, but they might be in breach of a fiduciary duty. In that situation, that's complex. That's not governed by the statute itself for some of those things. There may have been some situation where the members may be indirectly gaining or benefiting from it, for example. That's a little bit more complex. It's not it's not an overt defect, it's a latent one. It's one that's going to require the courts to do it. In that situation, you're going to have to rock up to court. Now, I think I'll talk about this a little bit later. Just from a practical perspective, there's actually a little bit of argument, judicial argument in the High Court as to whether or not standing is something you do on the day. So you rock up to court and you're going to seek your remedies and stuff, and that's just the first box that you have to tick, like an element, essentially, or a logical precursor, an element to a thing, or whether or not it's actually a two-step process. You've got to prove standing, and then you've got to do the other thing, which sometimes could be, if it's complex, two separate hearings. So there's some argument as to which of these is actually the preferred way of doing this. It's not clear. It's actually not a clear process. I'll talk about Griffith and Tang a bit later. Okay, so basically, if you are going to rock up and it's not something which is staring the decision maker in the face, you can just say, hey, look, you've sold this, and it says here you can't sell this. It says that in the Act. Did you guys read the Act? Oh, it sounds like, come on, who here is in the Law Student Society? None of you are in the Law Student Society at GCU? You probably should all be in the Law Student Society, if only for a bit of a laugh. Going through, which one? Yeah, don't go through and read the Constitution. Poor old Lenin's been going through trying to change the Constitution because, there's all these errors in it. I wrote it. There's probably errors in it. I don't know. It took me, a lot of trauma. And just make note, if you can rock up to court and you want a common law writ of prohibition, but even if it's not an error on the face of it, but your case is overwhelmingly strong, Your Honour, here you go. Here's this clear example from these three precedent cases involving interpretation of this rule. It's all of them overwhelmingly granted standing in that situation. Then you're going to have a much easier time doing that if you are not a person aggrieved. That kind of makes sense. There's the trouble with this stuff. It's bits from all over the subject. This is the sort of area where you can probably go back over this lecture a bit later in the subject to give yourself something of a refresher on the common law writs in relation to standing in other areas. It may make a little bit more sense. All right. So the word aggrieved, though, word aggrieved came from the old rule for certiorari. So again, that was when they tried to encapsulate that word into the statutory framework. I think they've widened it actually in common law. When a person's not aggrieved. Yeah, it is. So that these days the standing for certiorari is a little bit wider than what it is for a statutory right of review, in that you can do it in situations where you have some connection to it, but not strictly speaking, was it the two tests from Boyce, special interest or public right coexisting with a private right. And this discretion, yeah. Okay, so that there is some argument. This is the difficulty with administrative law I found teaching it last year and this year. When you're going and looking at particularly high court cases, it's not uncommon for them to be split in terms of decisions and for them to essentially go through, frame what this particular area of law is in different judgments that frame it in different ways. And so here, okay, so when we're talking about latent defects, those are ones that actually require the courts to go through and examine. It's not just on the face of it. And again, if we were looking for, when we're talking about prohibition, stopping stuff, you can do it if you're not aggrieved and it's a latent defect. If you've got a strong case, probably not if you've got a weak case. Now, this test for certiorari, because it's supposed to be, in theory, a narrower test than prohibition. Because if we think about it, a government decision maker or an administrative decision maker making a decision that's outside the scope of their powers, for example, if you think about it, anyone should be able to rock up to court, or at least a broader category of people should be able to rock up to court and stop it. That's the prohibition writ. Whereas making them change a decision, the idea is that the scope of that and the people that should be able to have the ability to rock up to court and have administrative decision makers change their decision should actually be narrower. And the idea was that when they were writing the ADJR and the JRA, this was the test we were going to use. We're going to use it for all of them just to make it simpler. But the argument here is that at common law, it's probably a little wider to get certiorari than just merely the equivalent of a person aggrieved under the statute. And there's disagreement about situations where we're wanting to seek a writ to get a government decision maker to change something, but the error that they've made, if it's really complex, some judicial and academic commentators say that, look, this test ought to be just the same. Person aggrieved should be the same as the statutory one. Others say that no, strangers can't do that in that situation. We should have a higher bar for people wanting to have decision change, because it's almost like those three great writs. The amount of hassle it creates for government is different for each. So prohibition, stopping them from doing something, well, you know, government shouldn't be doing things they're not allowed to. Stopping them is fine. Making them change decisions, that's a little bit more of a hassle in terms of the amount of effort and the amount of clogging up of government that can create. Whereas mandamus, making them do things, that's a different kettle of fish again. And we're going to interpret that one a lot more strictly. And so as a result, at common law, the test for getting a writ of mandamus, making a government decision maker do something, you must do something. You've got to spend public money to do that thing. We appreciate that all of these things cost money. But in theory, stopping government decision makers from doing things shouldn't cost as much money as making them do stuff. And then getting them to change things, that should be somewhere in between. And so this test for whether or not a person at common law can get a writ of mandamus is narrower than merely a person aggrieved. So we think about the statutory right, which is a person aggrieved, which is sort of halfway in between. That used to be the common law rule for certiorari, which is these days the common law ability the standing have is actually a little bit wider than merely a person aggrieved. But for mandamus, it's narrower, and it is still narrower. You actually have to have a more strong connection to the particular decision that's about to be made, that you want to get them to make, in order for this, so to pull this off, to have standing to bring the action. The phrases that they use there's a bunch of them, again, because judges like to hear their own voices in some situations, and so they phrase these things in slightly different ways. What have we got? Legal specific right, real interest, sufficient interest, or legal pecuniary or special interest. Look, if your dollars are going to be impacted, by government decisions, the courts are pretty happy to let you give it a go. And the more readily you can demonstrate your back pocket is going to be impacted by these decisions, the more likely you're going to get one of these writs. And again, mandamus is the hardest one at common law to get, because we're making a government decision maker or administrative decision maker do something. Okay. So, that essentially just restates, sorry, I've jumped ahead essentially. That's just a restating that. And ALA's case is a relatively recent High Court case that talked about that as well. You've got to be connected. You've got to, it used to be that, I think I'll talk about Boyce a bit later, that you had to suffer in some particular way. But it's really about having an interest, but having to have quite a strong interest that's impacted or affected in some way. Okay, so that's for mandamus. And look, really here for you guys, I think the key thing to note is just these three modes of writs: getting administrative decision makers to stop doing something, change what they're doing, or make them do something. Prohibition, certiorari, and mandamus, that the requirements for each, at common law anyway, are skewed. Prohibition's easier to get, certiorari is in the middle, and it's a little bit easier to get it than it is under the statute. Person aggrieved, it's a little bit wider. Used to be the same, now the common law test is a bit wider, but mandamus is harder. Common law test for mandamus to make a decision maker do something is a harder test. You've got to demonstrate some real connection to this that are specific. Yep. Yeah, triangle, pyramid, slope, right angle triangle. You do it as a little diagram, but I personally find doing law, sometimes you'll see lecture slides where they'll have lots of diagrams on them. I don't usually find them very helpful myself. I don't know about you guys. I'll do little diagrams if you want me to. A little diagram of this, that, and the other thing. But I find that when you come to study, when there's a little diagram and it's got 3 arrows on it and no text, and I just want the text, I just want to read the rules to be able to refresh my brain, I found it to be sometimes unhelpful. You've got, there's 7 gears on this screen. What does that mean? It's the elements of a contract, of course. Right. Equitable remedies. Declarations. Courts can declare anything about anything. They have power to do that. And look, because the relief granted is very, very similar to what you would get in other areas of law, and contract, I'm thinking particularly, they try to follow the same sort of rules in terms of granting these things. This is in terms of standing here. So that parties to a contract, for example, you've got the principle of the doctrine of privity. In fiduciary duties, Maddie, what's a fiduciary duty? Yeah, it's a very, very high duty that's placed upon a powerful party to look after the interests of a weaker party. And as such, when you've got governments, traditionally are the powerful party, and citizens are traditionally the weaker party, and they really want to try and mirror or really use these same principles in terms of granting remedies in equity. But declarations, though, just in terms of the administration of justice, are a very, very useful device, because the ability for a party to go and seek a declaration is essentially asking the court to say, look, if this thing is going to happen, can you tell us in advance what the law is? We'd really appreciate that if you can map this out now. And so sometimes you'll find that both the relevant government agents and the person who may or may not be affected rock up to court. And look, the courts in that situation, they're never going to deny a person standing if both parties want to determine what their rights are. It's a very, very, very low bar in terms of, I'm not saying that the court will determine it one way or the other to the favour of either party, but in situations where both, and that can actually happen, where you've relatively a lot, when a person rocks up, wants to go to court to determine what the rights of the parties are. Okay, just make note. Test of voice. So we're going to talk about voice because in ye olden days, and this is really the test for standing in terms of injunction, which was essentially the main instrument or the main writ that people would get in regards to government decision makers back 100 odd years ago. And so this test forms the foundation of the general test for standing that we have at the moment. This is the basis of it. So you'll hear me talk about voice, the limbs of voice. What's the difference between limbs and elements? Yeah, that's it. Limbs are disjunctive. You only need to prove one or the other. And there was an error. I had to go through the slides with Linda or Jamie or whoever, somebody had this on the slides from previous years, where there was an and. It's like, no, it's not an and. Oh, then the reason, sorry, let me rephrase that. The error wasn't Jamie's. The error is actually the decision in voice, where they use the word and. They meant or, but they used the word and. And that was just the context of the way the sentence was structured earlier. The two different things that you could use is this and this. What they meant in terms of an actual legal test is that you need to prove this or you need to prove that. So that if you read that, sometimes you'll see the word and, because if it's been copied and pasted from the voice itself, but you need to know that they are limbs. It's one or the other. I remember rereading this last year and thinking, what? I'm sure that this was disjunctive. Okay, now, this is the old test, and we will take a break very soon, and we'll talk about the new test, which is taking this and changing that second limb. Because where standing is problematic for groups or entities is not when an individual is about to suffer damage from their back pocket. Right? That's not usually problematic. If you're going to lose your house because a government decision maker has decided to bulldoze it, you're never going to have a problem with standing. Courts have accepted that for hundreds of years. Where it is problematic is where there is some public interest. And this is where things start to get a little bit tricky, and this is the bit that you guys will both have to learn and be assessed upon. Because this idea of the Attorney General as the person who is the people's lawyer, who will bring actions for the public good, is quite problematic when most of the decisions in this day and age that are made by ministries, they're made by government decision makers in ministries. And who's the Attorney General? The head of the Department of Justice. They're buddies with the other cabinet ministers. They're in the same government. And so the Attorney General being the person to protect and preserve the rights of citizens is a little bit tricky in this day and age. And so this test that's laid out in voice, it says that, look, in situations where the Attorney General is not going to do anything about it, you have standing as a citizen to bring an action, and here, specifically at the time, they're talking about injunctions, but this rule is now applied more broadly. If either the right that is being infringed, this public right that's being infringed, also impacts your private rights. So you're a subset of all of the people that are impacted by this particular decision. Or you suffered some sort of special damage as a result, or will suffer some sort of special damage peculiar to you as a result of this government decision, or likely result. Those are the two limbs of voice. And that first one is still the law, and the second one is changed. But we will talk about that after we go for a quick break. All right, I'll leave that on the screen. Okay, let's kick that off and carry that on. So, bringing back the previous slide, or the current slide, talking about voice and the two limbs of voice. That's the big thing involving standing, and that was from about the turn of the 20th century, where they're trying to really map out how much scope the courts are going to give people to bring an action where it's essentially a public right that's been infringed. If we think about the start of the 20th century, particularly when you think about the Australian Constitution and the things that are in it, you notice that there's no head of power in the Constitution for the environment. The environment didn't exist in 1901, and arguably when the High Court had to consider an application by the Australian Conservation Foundation in 1980, the environment didn't exist then either. And I say tongue-in-cheek, the High Court of that time, the guys, and they were all men, were, as we would use to describe them now, old school blokes that had probably pretty would hold those tree-hugging hippie types, leave them at arm's length. They would hold them as not being, I don't know, deem them worthy. No, that's not quite the right phrase. Let's just say they gave them short thrift in and around that time. And so the ACF, sorry there's a wall of text there, because it's it was essentially one of the early environmental protection cases. It came to the High Court, and it was to do with a resort in Yeppoon. And you can appreciate that Queensland, and it was probably the Berkey-Peterson era in Queensland as well. So you've got Berkey-Peterson as your state premier trying to push for all this development. We want cranes on the horizon. And you had Chief Justice Gibbs in the High Court. He was a Queenslander, old school, 4X drinking, no nonsense sort of a gentleman. And the arm-waving, bearded, tree-hugging hippie types that wanted to preserve the environment. They were up against it. I went to school in the 80s, and the environment wasn't a thing in my education, in primary school. We didn't do the equivalent of environmental science. It wasn't even a science as far as we were concerned. But oddly, the curriculum, I'm a Kiwi, so this was in Auckland and in Wellington, and the year after us, the 1 year below, they did start to put that into the curriculum. So that was something that appeared in my primary school the year after I left. I've got all sorts of stories about Muldoon. That is an old school gentleman indeed. And the ACF case, though, is the key thing that you guys need to know is that it changed the second limb of voice. And they talked about this. It's not a peculiar sort of damage. It's a special interest. All right, so long story short, they lost. ACF lost. All right, old school. Now, good old Justice Lionel Murphy dissented against this, but here they were arguing essentially I think it was a common law. It was a common law action, but or a constitutional action or constitutional writ. But they lost. ACF lost because the court said the ACF itself doesn't have a special interest in that particular place over any other body in the public or any other person in the public. Their interest isn't special or more special than anyone else's. That's what the argument was. The judgment, that is the law. That is the common law of Australia as we declare it. And as such, without this this having this special interest, this connection that makes them more somehow more special than other members of the public. It's not going to fly. And I've put this in here because there's a couple of key phrases in the judgment of Justice Gibbs. It was Chief Justice Gibbs at the time. I got that wrong. An ordinary member of the public who has no interest other than that which any other member of the public in upholding the law will not have standing to sue and to prevent this violation of the public right. All right, the correct person to do it is, in fact, the Attorney General. And of course, from a practical consideration, we know that that's gumph. The Attorney General in the state of Queensland in the Peterson era, I don't know who it is, but there's literally nil chance that they would go and want to bring an action in our Westminster system. All right, but this phrase here, an interest for the present purposes does not mean, and this is a good phrase, a mere intellectual or emotional concern. And that phrase comes up again and again when talking about standing. All right, it has to be more than a mere intellectual or emotional concern. And that's the one, that particular phrase is the one that gets picked out by laters. Now look, again, if it's your back pocket that's going to get impacted, easy. You're always going to get standing. All right? If it's not, if it is just intellectual curiosity or a small amount of care, it's not going to be enough. That's this special interest. It has to be more than that. And similarly, Justice Mason said, a mere belief or concern, however genuine, does not in itself constitute sufficient locus standi in cases like this. This is the environment's not really a thing, remember? And here, they're arguing that, sure, the ACF may care, but that's merely an intellectual concern. It's a feeling. We feel that this is bad. Well, that's not enough. That's not a special interest. So they've essentially remapped that second limb of Boyce. First limb is where your public rights, a public right and a private right sort of coexist. Your private rights getting impacted by the impact of the public right. That's fine. That's the easy one. The second one, which in Boyce was you needed to suffer some peculiar damage or special damage, they've broadened it. Here they've broadened that test to make it wider and say that it's more than that. Look, you have to have an interest, but that interest has to be above a certain threshold. It has to be more than a mere intellectual concern. Really, you have to, sort of suffer, for want of a better word, in some way. So, and to just make note, Lionel Murphy did actually dissent in that particular case. Now, you note though that they were talking about an injunction. And this idea of this being a convergence of this test. There's a lot of discussion about this, whether or not there is a convergence of this particular test for standing. Because ACF essentially mapped out what the law for standing is in Australia. Now, again, in that case, it was in particular to do with an injunction, but arguably the standing test is of broad impact or effect where you've got this public and private rights being infringed. Something bad is happening for the public, and look, most of the examples that you'll do for this subject involve decision makers making decisions involving public things, big proposal to do this, that decision to do this, rather than a small decision which impacts somebody. If a minister declines you a passport, makes an administrative decision under enactment to decline your passport, clearly you're going to have standing to seek review. That's not contentious. All right. So that if you think about this in the scope of this course, things that are going to involve public interests intersecting in some way with private rights or interests, that's the stuff we're concerned about here. We're not concerned about standing where the minister's decision is going to cost you $100,000. That's easy. You're going to tick that box in terms of standing. It's not contentious. You're going to lose, you said, your visa is going to be cancelled. Clearly you're going to have standing to seek review on that. We're only concerned here about this public-private difficulty. All right. So the second limb, this changing in ACF, this is something that, again, you'll have to talk about and think about and analyse. Because even though, some of them are, in the 80s, this went backwards and forwards. Went to the High Court a few times, went backwards and forwards to try and map this out. And I think it's helpful to just try and work out how broad and how narrow this second limb, this special interest test, is in terms of the judicial commentary. And I like to think that in a subject, this is a substantive law subject, it's a statutory law subject, you guys, you need to know more than just what's on the lecture slides. You just do. I've made this comment that I actually try to set up my lecture materials, to give anybody the opportunity to get 51% in this subject. If you want to get 51%, you could probably just take the lecture slides in to both the test, the presentation, and the exam. 51%. Go for it. And look, for some of you, that might be fine. I'll take 51. Thanks. See ya. See you next year. Not see me next year. Now, there's a couple of cases here that we're just going to talk about a little bit more. The first one, you always talk about differentiating themselves. All right, so this is specifically for the common law stuff, and the constitutional writs and the common law writs, prerogative writs. You have to be different. When the word special actually means something, you have to be different from everybody else when bringing a common law action. And look, at the end of the day, if you bring common law actions, it's like bringing a common law action in contract law. There's a whole statutory framework that's set up so you can go to QCAT. Miscellaneous deceptive conduct, just rock up to QCAT. Sort out your minor debt, your minor consumer dispute, that's fine. When you're having to go through the court system, lawyers have to be involved, things have to be complex, things have to be expensive. And here, the High Court actually has said that, look, you have to be special in some way. It's not a particularly high bar, but if everybody else suffers, particularly, there's one area where governments make decisions and everybody gets impacted, and that is tax. And so courts for a long time have said taxation decisions that impact you also impact everybody else. And as such, you don't get standing, at least not for common law actions involving that. The statutory ones, I appreciate for tax stuff, are actually mapped out by the statute in terms of how and where you go about doing things with the AET. But in terms of common law actions, if you feel aggrieved, sure, your back pocket's getting affected. Yeah, in theory, that would give you standing, but not in situations where everybody else is getting taxed just the same. You have to prove that you are somehow special. Okay, now these do come up. Right to life association. You can see where this one's going, eh? This again, courts. And this is the sort of thing that gets tricky. Look, it gets easier over time to talk about these things, but I've always tried to be a little bit careful about stuff. I'm a New Zealander, and the one thing I can tell you without any compunction whatsoever is that Australian culture and New Zealand culture, there are some key differences between those two countries, and one of them is about this stuff. In terms of pressure groups that have visibility in this country, your unions have way more visibility and power in this country than they do in New Zealand, and so does the Catholic Church. Those two entities have vastly more power than they do in New Zealand. Across the Tasman, don't worry, we have our own problems. The Real Estate Institute has way more power than it does here. You have no idea. They control a lot of stuff in the conversation. And farmers in New Zealand have a lot more power. It seems a bit strange. You guys think farmers have power here? Oh, no. Just wait till 19% of your economy comes from agriculture, and then you see anything that impacts farmers. No go. You'll notice that New Zealand Prime Minister, very progressive. She's younger than me too. There's a certain point in time in your life where the heads of state end up being younger than you. She backed down on CGT, capital gains tax. New Zealand has no capital gains tax. Why? Because the Real Estate Institute didn't want it. There you go. The miners, by the way, have no power in New Zealand whatsoever. Mining's a dirty word. You talk about doing mining stuff. All of the stuff with, what's the big mine? The Adani? That is just not a thing across the Tasman. Okay, but back to topic. This, talking about abortion, basically, in these sorts of classes, I'm always a little bit mindful because your culture is not the same as my culture. It is much easier to talk about these things across the Tasman. We're having a big debate about it at the moment. And it can form part of political discourse. Here it's much, much harder. I'm mindful of that you guys are culturally different from me. But the courts here are also mindful of that. And so that there is a trend, though, for the religious groups to have standing to bring actions, but they lose. There is a trend towards the courts being very sympathetic to religious groups for bringing actions to do with things like IVF, the use of sperm, and abortion, family planning generally. Generally, as a theme, the courts they set a very, very low bar to these groups to bring actions, but a very, very high bar in terms of actually them winning. And you can possibly work out why that is. Possibly. You may have your own thoughts on that. My thoughts is that your courts, even though we're talking here, 1980, good old Chief Justice Gibbs, pretty old school. Courts in Australia, particularly around in the 80s, the late 80s, went quite the other direction, ended up being very, very progressive. The Mason Court is known as being the most progressive and pro-rights, individual rights, as well as collective rights of any of the courts in Australian legal history. And it's not, again, surprising that these very, very progressive cases came through. Rogers and Whittaker, Vuayan's case, all of the Section 92 cases, and Mabo. It's not coincidence they all happened in that period between 1987 and 1992, 93. So, here, the courts had said here in terms of scope of things to bring action, what they tended to do from the 90s onwards is that rather than letting these religious groups go and bring actions, actually have standing go. So often what they would do is let them called amicus curiae, I think is the phrase, friends of the court. It's basically an ability of the court to let these groups not so much have standing to bring the action, but the ability for them to adduce evidence. They have their friends of the court. And so and that's why you will see things like this particular case, this party and this party, Party A and little locus B, Party B, and then it's got Ex Parte A, Bishops Association of New South Wales or something similar, that Ex Parte A. And so that's that idea that you can have these things, the religious groups can be involved in the process, but sometimes they're doing it to be able to adduce evidence and to adduce arguments, but they're not strictly speaking parties to it. And the courts have been happy to do that. But here, when they're talking and analysing it, the Right to Life Association, when talking about special interest to actually bring an action to do or bring an injunction, you have to prove some connection. You've still got to satisfy the special interest test, some advantage or disadvantage, which is different from the ordinary members of the public. You have to suffer or gain something which differentiates you as an entity, in this case, bringing an action. Again, this is similar to the one above it, and similar to the series of tax cases, which I haven't got here, but they're generally UK cases. Everybody gets taxed. Everybody has to do this, and everybody has access to the public healthcare system, and everybody has access to the public healthcare system equally. We can all go in queue for 3 hours. You can read into that. For those that know a little bit about economics, you can read into that as you like. We can all go to the public healthcare system. It doesn't make us special or not special as a result in terms of bringing actions against those sorts of public health entities. Now, these last two, this onus, Alcoa, and Co-and-Gordon, are important when we're analysing ACF, because really the history of ACF, the ACF case, was that they said no. ACF said no, and there's a case that came later. Oh no, don't die on me. Don't die on me, stream. There's a case that came later that said, in 1989, also involving the ACF. And it turns out, I think I've probably got it in the latest slide, it turns out that by the end of the 80s, the environment existed. How good is that? And so as a result, the ACF won when a similar matter came up with wood chipping in Tasmania, a working standing. But here, Onus and Alcoa and Co and Condon? It's Condon. Got Cordon. Double check that. I think I might have made a typo there somewhere. Okay. These both involved Indigenous people trying to determine whether they had standing to bring a particular matter against a minister's decision involving that particular area. There they said that, look, if we go back to ACF and we say that, look, mere emotional or intellectual consideration is not going to be sufficient, having affiliation to a particular area will be. You are part and parcel of the land. Indigenous Australians do have standing. Their connection to the land, remember this is pre-Mabo as well, but their connection to the land does give them standing to bring an action. So that Indigenous groups in relation to dealing, and again these involved land areas that had cultural artefacts on them, I think both cases did actually, a bunch of cultural artefacts. They said that that is more than a mere intellectual concern. There's deep-seated spiritual connections. However, and that's what Onus and Alcoa was basically about. Alcoa was an aluminium company. And Onus, don't know if it's related to the Onus family that is here, I'm not sure. I'll have to double check. But Onus and Alcoa, they said that, look, being connected to an area and your Indigenous ancestors having that connection there, that is far more than a mere intellectual concern. But that's not what the court said in Co, or rather, what they said is that, look, yeah, having a connection to an area, yeah, that is fine. But being Indigenous itself is not. So that was the distinction or delineation that they made between those two cases. In Co's case, they said, yes, you're Indigenous, but you are not connected to this particular area. That is not going to be sufficient. Okay? So leave that one, tuck the one in that one in the back of your minds. All right. I think I've actually repeated this. I think I've repeated this from an earlier slide, but just make note that there's this this convergence. There is this tend towards a convergence of the rules of standing. Look, this is a little open-ended. I don't really apologise for that. Fundamentally, this is an argument that I've had for people for forever and a day. I do a little bit of legal practice, a little bit, not much. I'm largely an academical type And my research area is in the intersection of coding and legal writing. It's not something that really comes up much in practice, really. It's fundamentally grounded in the academic experience. But a line that you will hear me harp on about is that this is a university, not a TAFE. And the level of understanding and intellectual engagement that you guys have with subject matter at an AQF level 7 level, which is your an undergraduate degree, is just deeper than mere training. When people say, we're training you to be lawyers, no, this is a university. If the profession wants people to do TAFE courses to become lawyers, that's fine. The profession can legislate. They essentially just write the Legal Professions Act anyway. They could just go and change that if they wanted to. All right? But this clash that I have all the time with profession saying, we don't teach you guys no practical stuff. It's like, well, if you want it to be solely practical, turn it into a TAFE course. You guys need to know about this stuff in more depth than merely being able to tick a box and flick and go through the lecture slides. And that's why I say for this, follow the lecture slides 51%. And that's sort of my kind of response to that. And if the profession wants graduates to come out with a 51% grade point average to go out and fulfill the jobs of the ever-changing legal profession, well, good on them. Do I sound a little bit grumpy? I'm not trying to come across as grumpy, but I feel this question a lot. And so here, there is some academic commentary that suggests that there is a convergence, but I cannot tell you with definitive clarity if this went up to the High Court again, which way it would go. But I can tell you that the rules for standing for habeas corpus, so these are the rules I've talked about, the special interest test. Originally that was for injunctions. There is a convergence that it's actually going to apply for all of the common law and the statutory writs, but for habeas corpus, nah. The bar for habeas corpus is the lowest you could possibly imagine. Somebody's been locked up by some, the ACCC have come in, grabbed your stuff, and then put a mask over your head and locked you up in their offices. The level or the bar that a person to bring an action to get that person out is very, very, very low. There we go. So there you go. Any person who knows of another being wrongfully in prison has the right to ask the court to bring them forth. And that was restated in the Tampa case, Ruddock and Valdalis, which is part of the shoot this week. We've done those things ahead. Okay. Right. I mentioned that in Queensland, they've taken the word writ and just kicked it out. But Justice Chesterman, in that case, that Carlson case, said, when the Queensland government came and just removed the word prerogative orders, removed the word writ and just replaced them with order, that they didn't in no way, shape or form change the law. No way, shape or form. Now, there is, again, some academic commentary, which you can feel free to read in the Crakey text. The other text, which I cannot remember, the Green Book, that is the prescribed text, I'm not sure it goes into this in too much depth. There is some academic commentary that the High Court writ under Section 75, sub 3 and sub 5 of the Constitution is a little bit different to the prerogative writs of the courts themselves. I'll say that again. There is some academic commentary and some judicial commentary. I believe Justice Kiefel, in a few cases in the last 10 years, she's been around about 10 years, has talked about whether or not there's a distinction in terms of standing for what we call constitutional writs, which is applying straight under the Australian Constitution, as opposed to applying, strictly speaking, through the common law in the states and under Section 39 capital B of the Judiciary Act, which are essentially common law actions. There's there is some commentary that there is a constitutional, which essentially flows from there being a constitutional right to do something. But individual judges have talked about it. There's no binding decision on this because, to be honest, it's really more an academic point in terms of standing. There haven't been any cases where this has actually been a substantive issue because it has to be a very narrow set of circumstances, for example, where you would get standing because it's a constitutional thing, but not standing if it's common law. That idea that you could go to the High Court, but you couldn't go to the Federal Court. These things haven't really come up. It has to be a very, very narrow set of circumstances where you get one and not the other. And judges are loath to map that distinction out because common law writs are a pain in the backside. You can't go through the statutory framework to do them. This stuff is opaque enough for citizens. Most people have never heard of the Judicial Review Act or the ADJR. This stuff is hard enough to start with. When you're having to throw in the fact that we've got these inherent constitutional and or common law writs as well, it makes it harder again. And the courts really don't want for that to happen because the only people who win from this are the expensive barristers. They're the real winners when this stuff ends up trotting off to court. So just make note there. In Queensland, we use a different name. The law is exactly the same. And oddly, I have only one slide for this. Person aggrieved. That is a person who is aggrieved by a decision made under an enactment has this statutory right to go through and have standing to do that. And look, it's... Oh, that was a bit slow. And this idea of standing being easier, some commentary suggests that that is the case. The person aggrieved is broader, and it certainly is for mandamus. If you're making a government decision maker do something, in theory, it is easier to do that because a person aggrieved is a wider category than merely a person who suffered some sort of, has some special interest in that matter, suffers some sort of special damage. The rights have been seriously infringed. Now, however, as I mentioned earlier, the common law test for certiorari is arguably wider than a person aggrieved. And there is some commentary to say that that's not the case, and when the common law definition for certiorari widens, that also widens the statutory definition as well. So some commentators on administrative law say that this is actually the same thing. Arguably it's not, and the two tests, the test for certiorari and common law, is arguably still different and arguably wider than the test under the statute, an aggrieved person. Some commentators say that it's always the same. These things are actually the same thing. And just make note that prohibition is probably still wider again in the common law than merely a person aggrieved. So we've sort of got this situation. You try and visualize this in your head. I'm at loath again to use diagrams where at common law, mandamus, the standing requirements are narrower, it's a higher bar. For certiorari at common law, it's quite similar to the statutory one, a person aggrieved. Some commentators say it's wider, and other commentators say as this gets wider and wider, that the statutory definition widens as well. And most commentators argue that that prohibition in the common law is wider than merely a person aggrieved. So getting a government to stop doing something, is easier to do in common law to bring an action than it is under the statute. Okay, and that's really all I have to say. But just, make note, there is a little extra sub definition. A person whose interests are adversely affected. A person whose interests are adversely affected by decisional determination. The reason why they put this in, we want, when we codify laws for a citizen, these aren't my words, these are the words of the philosopher Jeremy Bentham, we want the citizen to merely to be able to open the book and see what the law is. And you guys have been studying law for long enough to know that really doesn't work. Who here studied criminal law? Does the code contain all of the law and all of the words that are needed to interpret that law in the state of Queensland? Oh no. Oh no, it doesn't. And you'll notice also that the criminal code's, about 100 odd years old? And pieces of criminal legislation that have been passed since then, for example, the Drugs Misuse Act, don't attempt to codify the law. You found that quite interesting? The state of Queensland, for example, the definition of possession in terms of drugs. Is that in the code? Is that codified in the Act? No, it comes from the common law. So there's almost this push away from trying to map everything out because they appreciate it's just too hard. It's too hard to put everything in there. So they're trying, but we appreciate as law types that we know more about this stuff than most people do. And for you guys now, I hope this is useful because, again, this subject is about reaching that hurdle. Once you've reached that hurdle and you know how and where this judicial review thing, how it works and how it operates, going down the other side of the hill is just going to be easy as. You're going to smash it. But we're still at that stage, probably going up that hill. So apologies if some of the stuff is repeated. Some of the stuff was repeated from earlier bits. Some of the stuff is repeated from later parts of the subject, which we're going to go over again. But it's incremental. It's incremental while we're climbing the hill. So I'm going to leave it, I think, there, even though we're a couple of minutes early. I apologise for the microphone issue at the start. Apologies for that. I have to think I may have to do some sort of voiceover or something. I'll have to think about that. Those that are watching this online, but for those that aren't there, I'll just make note that I'll send an email and announcement around for anybody that can come in on Saturday. Thanks, team, and I'll see you guys in the chute soonish.